Judge Mullins, I apologize. We're running a little behind schedule, and we welcome you for your opening remarks.
Thank you, Justice Wiggins, and ladies and gentlemen of the Commission. It is a pleasure to be in front of you again. In fact, it's just a pleasure to finally get here and get going with this.
We could take another break if you want.
The waiting is the part I haven't enjoyed. You know, I've appeared in front of you folks before, and I know you have considerable materials concerning me in the responses to the questionnaire and the writing samples and so forth. So I know you know a lot about what I've done and where and when. And so as I tried to think about what can I do with a few minutes in an opening statement that might be meaningful to you, I decided to focus on three terms that I think help tell a little bit about who I am. And as I do that, I'll weave in some of those references that are in the materials that you have. Practical, pragmatic, and passionate. I tend to be practical in my approaches to problem solving. In my personal life, certainly. In private practice, when I practiced law for 19 years, I tried to be very practical in trying to find solutions to my clients' issues and problems. Those of you in private practice know that a lot of times folks come in and they just start telling you all about their problem or their issues. And I found early on in my practice that it was very helpful to ask a pointed question: what is it you want me to do? And from that, then I could begin to formulate what is a practical solution or a practical method by which we can address the issues that they have. I've also tried to be very practical in my role as a judge. In writing rulings, I try to be practical in fashioning remedies, fashioning responses to the arguments that are presented to me, especially in the area of family law, dealing with asset distribution, debt distribution, custody and visitation decisions. I had the experience as a lawyer from time to time to get rulings that were fair, they were equitable, but they didn't work very well. And so I've tried to make that an area in which I focus as a judge. As a judge. So transitioning on to then, the other area that you'll see that as an example of my being very practical is in the development of my criminal statute summary chart, which I know that most of you are aware. That was a very practical response by me to a problem I had as a judge in trying to make my way through the kind of morass of criminal statutes in Iowa, especially as it relates to sentencing issues, and in particular as it relates to drug offenses and the various surcharges and penalties and enhancements and so forth that follow from that. Pragmatic. Pragmatic, for me in this context, is kind of an extension of or an expansion of practical, that is, taking it to another level. There's a couple of examples of that I'd like to mention in the writing samples, and then I'd like to also address my involvement in the legislative process. In the Bentler decision, you'll see at one point, I think it may be the last paragraph under my findings of fact, I indicate that there are a number of other facts and issues that I'm not going to address because they're not necessary for this ruling. In particular, in that case, there was evidence, I don't know if considerable is quite right, but there certainly was evidence presented by the prosecution concerning motive. And there certainly was considerable argument concerning motive. And even in an early draft of my ruling, I addressed motive and talked about why it wasn't going to be a factor in my decision. But the pragmatist in me said, why am I talking about something that I'm not going to use in my decision? And instead, I just took that all out because although motive can be important can be important when a judge or jury considers premeditation or intent when it comes to certain crimes. In that particular case, that evidence was not compelling enough, and I didn't consider it necessary for the ruling, and so I tried to focus just on those matters which were necessary in order to reach the conclusions that I had to reach. I think that the mere fact that a 5-day non-jury trial was boiled down to a 20-page ruling is evidence in and of itself that I was pragmatic in how I approached the resolution of that case. Likewise, the Cubitt ruling that you have, I think it's about maybe paragraph 3 under analysis and ruling. Might be paragraph 4. I should have double-checked before I came in. But that likewise, I make reference to the fact that there are a number of other facts in dispute. There are a number of other legal issues that have been raised, but for the purposes of this ruling, I only needed to address the particular facts which were not in dispute and the particular legal issues around which that ruling on the motion for summary judgment was fashioned. I had an opportunity over the course of the last 3 years to be a member of the Interim Legislative Study Committee for Criminal Code Reorganization, and as a result of that, I was chair of the Sentencing Subcommittee. The Sentencing Subcommittee ultimately approved proposed legislation for the adoption of and creation of a Public Safety Advisory Board. The Sentencing Subcommittee made that recommendation to the Interim Legislative Study Committee as a whole, which approved it. That legislation went through the legislative process with a few changes, but essentially survived the same and was ultimately signed by the governor, and the Public Safety Advisory Board is now in place. I'm very pleased to report that last Friday I had an opportunity to attend a training session for the Public Safety Advisory Board that was co-sponsored by the National Governors Association and the Pew Foundation, and I was really excited to see that board actually functioning and working. How's that tied to pragmatism? I guarantee you that there would be no Public Safety Advisory Board if it weren't for taking a pragmatic approach to arriving at a solution that other members of the committee could agree and which could ultimately be fashioned into legislation. That board did not end up being what I originally had thought it might be. It didn't have some of the components, but the ultimate product certainly accomplished the original goals, and I'm very proud to have been a part of that process. Passion. Perhaps you've already even sensed my passion about some of these things. I tend to be passionate about matters in which I'm involved. My involvement on the Interim Legislative Study Committee for Criminal Code Reorganization was really spawned by my criminal statute summary chart, which incidentally I prepared just for me. I prepared it as my tool. As others became aware of it, others became interested in it, and ultimately now you can find it on the Judicial website, County Attorney's website, Public Defender's website. It's a tool that's used widely throughout the state. But that also then opened some doors for me to talk about some of the complexities in the criminal statutes and sentencing laws, which then caused me to be one of 2 judges invited to a government oversight committee of the legislature several years ago. As a result of that, later on I was invited back to another committee. I think it was a joint session of Public Safety Committee and Judiciary Committee, and then ultimately was invited to be on this Interim Legislative Study Committee. I submit to you that all of that happened because I showed a genuine interest in and passion for trying to improve those areas. I could give you other examples, but I know our time is precious. But hopefully that provides a framework or a method by which it's helpful for you to kind of look at me and think about me, because ultimately I know that as you consider everyone's qualifications, there's going to come a point at which at least some decisions are going to come down to who is this person, not just what did they do, but who is this person. So that's who I am.
Judge Mullins, thank you very much. I'd like to ask the first question. You have a background in social work. Can you tell us if or how that may play into you being working on the Supreme Court?
I guess the best way I can try to respond to that, Justice Wiggins, is to give us some examples very briefly of how it impacted me as a lawyer and as a district court judge, and maybe by extension then into the Supreme Court. Certainly as a lawyer, that background was helpful to me in a couple of areas. One, it helped me identify when I needed to not counsel my clients, to refer them to professional counseling, because I had an idea of what those services were about and what they were like. It also allowed me to have a better understanding of my clients and their issues and problems that needed to be dealt with in the legal arena. Similarly, as a district court judge, as I hear testimony from mental health professionals, I think I have a better background than a good number of other folks for understanding some of the terms that are used, some of the approaches that are used, and so it just helps me have a better understanding of all of that. Also in the area of, this might surprise you just a little bit, but I guess as a district court judge, my background in social work also has helped me, I think, dealing with juries, because one of the things I studied in connection with my master's degree in social work was working with groups of people, small groups and large groups. And the large group dynamic of a jury, a courtroom full of 80 or 90 or 100 folks, especially for some major trials that I've had, has been very helpful to me just in having an understanding of those dynamics and kind of when to push and pull a little bit.
And you think those skills of dealing with groups would spill over if you were appointed to the Supreme Court?
Thank you. Yes, I do. I think both in dealing with public as well as, frankly, in dealing with fellow justices and other members of the judicial branch.
Thank you. Any questions? Mr. Holm.
Good morning, Judge Mullins, and thanks again for your application. You've obviously had an outstanding career as a district court judge, and as our Supreme Court is currently configured, I believe there's only one justice that has district court judging experience. Would you share with us your thoughts about how being a district judge would prepare you or has helped you to gain the skills that you think might be helpful on the Supreme Court?
Yes, thank you. I guess I'd like to preface by saying that I don't think being a district court judge gives you a trump card in this environment. I think you folks have to look at all of the qualifications, but among those qualifications to be considered for some folks will be their experience as a district court judge. For me personally, then, to try to respond to your question, I've had the opportunity both in my 19 years of private practice and now 9 years as a judge to see a wide variety of cases, to decide a number of different issues, to hear a lot of different fact patterns, to research a wide variety of the law. Frankly, I then also had the opportunity to take and apply Supreme Court decisions and Court of Appeals decisions in my everyday work as a district court judge. And so those experiences, I think, would help me understand that as a Supreme Court justice, they obviously have to decide the difficult cases that come before them. They have to do that in a scholarly fashion, and but they also need to always remember, and by saying this, I'm not suggesting that they don't now, but they need to always remember that they're writing those decisions for the litigants, for the people, and ultimately they're deciding the cases that are before them. Granted, because of precedent and stare decisis and those concepts, the Supreme Court needs to also be aware that their case decisions are liable to be expanded or liable to be viewed and used in other contexts, maybe even in types of cases which they had not contemplated. Well, they have to contemplate those and think about those sorts of things. So I guess in short, I just think that the combination of my background together with my work as a district court judge has helped me appreciate, I think, the work that a Supreme Court justice needs to do. I might also add that for me particularly, study committee also has given me an appreciation for some of the work at the legislative branch, and I think that might be a helpful background as well.
Any other questions on this side? Mr. Cook?
Judge, I was going to ask about your social work experience, which I think is really unique and a tremendous asset to your application here. So I'll just make a comment. You and I were classmates some 30 years ago. You've done our class proud.
Thank you, Mr. Cook.
Ms. Walker?
Thank you, Judge Mullins. My experience with you has been that you're fairly humble, so I'm not trying to embarrass you, but you are one that's received a significant amount of letters from the bars where you work and where you have people appearing in front of you, and I know that those were not solicited by you. So I guess, can you tell us a little bit about what you think it is about you that would lead to all of those bar members being willing to send in packets of letters in your support without them being solicited from you?
Thank you. I haven't seen any of those letters, so I don't know what their content is.
They're all good.
But I try very hard to be fair in dealing with lawyers. I try not to take myself too seriously. There's certainly opportunity for some levity and some being personal and friendly, but there's also a time for business. And when we get down to business, they know that I mean business and we're going to get the business done. And I try to do that professionally. I try to be respectful to everyone in the courtroom, be they self-represented folks or anyone else. I think if you ask around to the lawyers, you'll find that there are very few of them that are ever addressed by first name by me. I do that because I consider them to be professionals. They're calling me judge. I'm going to give them that respect as well. And it's only in social settings that we'll get familiar. And yet, like I say, I think I've found a way to both convey that professional, formal atmosphere, but at the same time, not an unfriendly atmosphere. The other thing that I think is that I suspect might play into that is that I try very hard to get my rulings out and get them out quickly. I've been a little slower lately with some of the pressures, various types of pressures, but I think I have a reputation of getting decisions done quickly and trying to write them fairly. I also took to heart several years ago a comment, and some of you will know who this came from, but I don't want to drop names, but a comment by a former State Bar Association president who cautioned against poison pen writing. And I've really embraced that. I try very hard to write rulings that avoid saying negative things about people. Now sometimes I have to, but I try not to, and I try to focus just on the issues that are before me.
Ms. Deneve?
Just a quick question. There's an administrative aspect to the Supreme Court, and I think it needs to be shared with people that you have established various group homes, boys' homes, and so forth, and so you've had to work with a very limited budget, and you establish these around the state. So I think that doesn't really share that you do have administrative tendencies to work within tight budgets, which we're facing now.
Yes, thank you. That was a nonprofit organization. Yes.
Mr. Fitzgibbon?
Thank you, Justice Wiggins. Morning, Judge, and thank you very much for being here. I want you to know that because you know Mr. Cook, I won't hold that against you.
Thank you, Mr. Fitzgibbon.
There's some on the commission that might, but I want you to know that I won't. On a serious note, I'd like you to comment on the amount of time you have devoted to your fellow judges and to the citizens of the state with the sentencing guidelines, so to speak. I've had 2 judges from my part of the state that have told me that they want me to be sure that you assure all of us that if you're selected to the Supreme Court, you'll continue doing this. So number 1, how much time has it taken? And number 2, when I go back to Northwest Iowa, can I take with me your assurance that you'll continue doing this if so chosen?
Don't you want him to read the ethics rules first before he commits to that?
Well, I
Thank you, Justice. I was actually going to rely on those, Justice Wiggins. I see my lights red.
No, keep going.
Okay. Yes, go back and tell those judges that I can't make any promises or pledges as a candidate for office. One of the fun things about that happened after my development of my criminal statute summary chart, and then I was ultimately invited to make an annual presentation to at the annual judges conference for the CLE conference in, I think, 2004. Since then, I've been invited back every year, I think, except one. I've also had the opportunity to give CLE presentations to county attorneys at their training sessions and to the defense bar. But in that process, then, each year I'm invited to give this talk, and every year it's like, okay, what am I going to do new this year? How am I going to do this a little different? And over the years, I developed some sentencing forms that I thought were more helpful, more efficient way, and more accurate. And I ultimately shared those, and so those are now also being widely used, both by county attorneys and by judges throughout the state. And I am pleased. That's one of those things about which I've had a passion. And in fact, in the development of those sentencing forms, I talked to a parole board member who happened to live in Washington, Iowa, and told him kind of what I was up to, and he got all excited because on the parole board they just see a wide variety of forms and judgment entries, some of which aren't very good. And so as part of my research and background there, he ended up gathering up for me about 20 different samples, and from those then, in my own experience, and trying to fashion around being able to use my chart and kind of gather the information together, I developed those forms. And again, that's been one of those things about which I've had a passion. Hardly a week goes by that I don't get an email from some judge or lawyer around the state on a sentencing question.
Thank you for that.
Thank you.
Mr. Pace?
Yeah, thank you, Justice Wiggins. I know I'm short on time here, Judge, but I wanted you to speak just for a second about the EDMS, because you had been involved in that quite a bit. And I don't, you may have mentioned it earlier, but I don't really think you have much, and it's not really much in your materials either. So could you just talk about what you've done on that and how it's going?
Thank you. Actually, about 5 minutes ago, it occurred to me that I had forgotten to mention my judicial technology involvement and EDMS, so I appreciate having just a few minutes to mention that. I've had the pleasure for the last 6 years or so to be on the Judicial Technology Committee, which is a committee that advises the Supreme Court on technology policy, and one of the projects of judicial technology has been the promotion and moving forward with the EDMS project, which is Electronic Document Management System. We're now in pilot in both Plymouth County and Story County. I see that as a very important project in the future of the judicial branch. I see opportunities for us to examine how we do business in the future, and we've got some bumps in the road right now in Story County. So anybody in Story listening, I know that we've got some bumps. And in fact, Business Advisory Committee is going to be up there next Tuesday doing an on-site examination of the problems because we're going to get them addressed, we're going to get them solved. We've got full support from the Supreme Court to make this project work, and we're going to do it.
Thank you, Judge.
Thank you.
Any other further questions? Judge, I really appreciate you, and I do think that if you were appointed to the Supreme Court, we'd love to have you prepare these forms for the judges around the state. So,
Thank you, Justice. Thank you, Commissioners.
thank